The network made an unparalleled contribution to quality, diversity, and equity by hosting guest talks with judges from the Supreme Court of Ukraine during the Russia-Ukraine War, as well as the Supreme Constitutional Court of Palestine and Supreme Court of Israel during the peak of the Middle East crisis. 70% of participants during Global South Network activities since its launch in March 2023 were women. We demonstrate the Global South is not a passive recipient of ideas but an active contributor shaping global norms. Today we are privileged to host Honourable Justice Michail Pikramenos, President of the Hellenic Council of State, Supreme Administrative Court of Greece.
I don't like the long presentations and the long speeches. Dialogue is better than monologue. The case law of the Court of Justice, the European Union and the Strasbourg Court has been instrumental in modernizing national approach to important issues in the field of rights. There is a violation of the European law. The Special Supreme Court, our court, was wrong, in very simple words. Public trust in the European judiciary varies significantly from country to country. However, the level of trust cannot be viewed as distinct from the general differences between high trust societies, mainly in the northwest of Europe, and low trust societies, mainly in the south and east. Historical, social, and economic reasons account for these differences. Trust is the bedrock of any successful operation, whether it be private or state. Judiciary is not in competition with other branches of power, but it is fundamental that trust established and there is a recognition of its independence in the way of its function.
Deseo expresar mi sincero agradecimiento al Dr. Naumen Riaet, la conferencia dada por el magistrado Michail Pikramenos, presidente del Consejo de Estado Helénico de Grecia.
Dr. Naumen Riaet, the founder and convener of the Global South Network, his visionary leadership has established a vibrant forum where judges, academics, and practitioners from around the world can share and exchange ideas. Initiatives like today's dialogue allow us to compare jurisprudence, share best practices, and develop common principles. This has the potential to contribute to transnational standards in procedure and enhance administrative law globally.
I would like to point out that Dr. Riaet's initiatives have not only enriched comparative judicial dialogue, have also fostered mutual understanding of the diverse challenges that courts face in safeguarding the rule of law and constitutionalism. In these days of backsliding of the rule of law, rising authoritarianism and polarization, it is of utmost importance to strengthen mutual understanding and trust.
Despite the fact that Russian armed forces have been near Kiev, the Cassation Court did not stop its operation concerning judicial proceedings and continued its work. Despite the Russian invasion and air alarms, other horrible things of war in all our Ukrainian regions. To express my appreciation for your assistance, for your help in our fight against unjustified war.
Supreme Courts are sovereign. We can rule the way we want in the cases which are brought to us by citizens and residents. In the EU, this openness of mind is increased by the fact we apply, in some cases, same norms from the EU treaties or the EU directives or regulations.
great initiative.
It's a wonderful initiative.
The Global South Network opened new horizons for judicial cooperation. Global South Network provide a platform for meaningful dialogue and collaboration, fostering efforts to build a more equitable and resilient legal landscape.
GSN network continues to expand areas of activity, further strengthening its impact and reach.
The universal concept of justice compels us to join our efforts, and this is, I believe, the forum for promoting the same goal.
Well deserved for the hectic activity you have made. I am astonished, I am amazed, I was impressed.
May I at the outset commend you, Dr. Ayad, for the immense work that you're doing in the GSN. The Global South Network is a much admired initiative.
كانت جزء لا يتجزأ من الدولة العثمانية.
We are being criticized for doing our job and for upholding the federal constitution. Like I have said in the past, I will not bend to such lame pressures and insinuations.
It's commendable. South Network focuses on all disciplines and regions, creating a bridge between academia, civil society, legal community, etc.
Now I would like to open the floor to question and answer session. So I invited all for this event to submit their questions in advance or during the session if there's any comment, any questions I have received. But before reading out that question, I would like to invite the discussant if there is any question. First question I received: how do you see the nature and the scope of relationship between the Supreme Administrative Court Greece and these supranational courts? Is it one of the conflict, or is it cooperation, or is it a combination of both?
The academics have written a lot about the supremacy of European law, the relation between constitution and European law. I must say that judges are scientists, but at the same time are practitioners. So without great theoretical schemes, we try to co-interpret the co-interpretation of the rules and to implement the rules as a whole, as a body. This is our difference from the academics. We can find good solutions without great words, great phrases, but next steps in our text of judicial decision which help the country in Europe. So in real terms, we have faced this problem without theoretical schemes.
Thank you very much. Second question, and I think that second question is for all panelists. Some of the organization associations were highlighted in comments and the discussion of some of the respondents. And the question is, so what's the nature and the scope of cooperation among different courts? How do you see that? Is it something successful, or are there any challenges facing this cooperation? And what are the objectives, if it is successful, we are going to achieve? So I will start with the Honourable Chief Guest, and then I will go to Justice Yves Gounin and then Justice Kari Kuusiniemi, who have already raised their hands. Any comments from you, Justice Michail Pikramenos? In that case, I would go to Justice Yves Gounin. Over to you.
Thank you, Mr. Chair. This is quite an interesting question, and I want to emphasize maybe two aspects. When it comes to international cooperation, there are two frameworks. One is that we work together because we have to do something together, because we are compelled to do something together, because the international community expects us to do something together, because the international standards of the law impose to us to do something. This is not the case of Supreme Courts. Supreme Courts are sovereign. I will come later to the specific case of the EU. Supreme Courts are sovereign, and we can rule the way we want on the cases which are brought to us by citizens and residents in our own countries. But it's very interesting to know what the neighbor is doing in a similar case. So, good sense and reason impose to us, with our open mind, to go and ask to our German, Spanish, Italian, Greek, Finnish neighbor, oh, you have had the same case, and how did you rule on this case? In the EU, this openness of mind is increased by the fact that we apply, in some cases, the same norms from the EU treaties or the EU directives or regulations. So the fact that we are members of the EU is even stronger impetus for this discussion. Thank you.
Thank you, Honourable Justice Yves Gounin, Council of State of France, for your reply. Now I would like to go to Justice Kari, Kuusiniemi, President of the Supreme Administrative Court of Finland.
Thank you, Chair. My friend Yves said very much the same things what I wanted to say. I'm trying to then take a little bit different approach, starting from a cooperation within the ACA Europe, which was already mentioned. So I think, as just like Yves put it, we apply the same legislation, more or less. So I would claim that our cooperation is very successful and goes right to the point. So the more closely you share the same provisions of law, same principles and so on, the more fruitful the cooperation is. And then the cooperation of European Union countries with the the European courts. It's a kind of dialogue, for instance, between the EU Court of Justice, dialogue starting with reference of preliminary ruling. So we discuss with the court and they answer something and we decide in our judgment something. And it's also a way to develop EU law and its interpretation. And with regard to the Strasbourg court, I already mentioned in my comment the Klima Seniorinen case, which was clearly the basis of our changed national interpretation of law. So we put high regard on the assessment of the Human Rights Court and decided that we have to interpret our national norms much more extensively than would have been the case otherwise. And my last two comments are about the Nordic cooperation. We have a very close cooperation between the 5 Nordic countries, which can be based on very similar cultural and historical and societal background. So it's all really straightforward and fruitful. And last comment, we have also established bilateral relations. For instance, tomorrow we will receive the President, Vice President, Justices from the Constitutional Court of Slovenia. Finland has no constitutional court, but we have the same issues. We apply the same EU law. We have same constitutional principles applied from different angles, but we have found it's very interesting and important. Thank you.
Thank you, Honourable Justice Kari Kuusiniemi, President, Supreme Administrative Court of Finland, for your reply. I think Honourable Chief Guest wants to respond. So over to you, Honourable Justice Michail Pikramenos.
Yes, I would like to notice that our relation with the other European Supreme Courts exists in our daily work. For example, the rapporteur judge, when she prepares a case, always read the jurisprudence of French, Conseil d'État, German court, of Italian court. We need this information. And during the meetings, we always talk about the other European administrative Supreme Courts. And we feel more comfortable. The work of a good judge is connected with his or her ability to give information from the other European court. This is very important for our court. And this is, I think, our difference from other courts in Greece. And we have daily dialogue with this way. And we have in our decisions references to Conseil d'État, to German Supreme Court, to USA Supreme Court, and we feel lucky because we live in the Western world. And if we compare Western Europe and North America, I feel that we have a lot of ideas and principles, and we have a dialogue in a democratic framework. This is a value, and we must hold these values.
Thank you, Honourable Chief Guest, Justice Michail Pikramenos, President of the Hellenic Council of State of Greece, for your reply to the question. I have one final question, but that is with regard to the last slide of Honourable President of the Supreme Constitutional Court of the Ukraine Supreme Court, Justice Michail Samokovich. What are the specific challenges that the court is facing while operating and functioning in a context shaped by the war with neighbors?
The war gave birth to a lot of challenges in the work of the Administrative Cassation Court.
Найбільші виклики – це зв'язок із учасниками у справах.
The greatest challenge concerns the connection with the participants of the cases.
І повідомлення, і збереження їх процесуальних та інших прав під час розгляду справ.
And preserving of their procedural rights during the consideration of the noted cases.
Не дивлячись на те, що російські війська були біля Києва,
despite the fact that Russian armed forces have been near Kyiv,
Касаційний суд не переставав здійснювати судочинство і працювати.
The Cassation Court did not stop its operation concerning judicial proceedings and continued its work.
У зв'язку з військовим станом виникло дуже багато справ у сфері публічних відносин.
A lot of cases concerning the public relations appeared because of the martial law.
І основне завдання Касаційно-адміністративного суду – забезпечення єдності судової практики було непростим.
And one of the main tasks of the Cassation Court ensuring the uniformity of case law was not easy.
І не дивлячись на окупації певних територій, усі адміністративні суди системи адміністративних судів України працюють, крім Херсонського окружного адміністративного суду.
Despite the occupation of certain territories, all courts of administrative jurisdiction function except for the administrative court of Kherson Oblast or region.
Шляхом постійного діалогу із суддями всіх інстанцій адміністративних судів, при допомозі цифровізації, при допомозі конференц-зв'язку,
by means of permanent dialogue and communication with judges of all instances of administrative court with the use of digitalization and video conference connection.
Нам вдається забезпечити єдність судової практики при розв'язанні нових спорів у сфері публічно-правових відносин.
We managed to ensure the uniformity of case law while considering new cases in the ensuring of public dialogue.
Крім того, ми дуже тісно співпрацюємо із Європейським судом з прав людини.
Besides, we closely cooperate with the European Court of Human Rights.
Крім того, ми постійно на зв'язку з Європейським судом справедливості Європейського Союзу.
We also cooperate permanently with the Court of Justice of the European Union.
Ми постійно проводимо міжнародні конференції, на які запрошуємо і вас.
We often hold international conferences to which we also invite you.
Це була конференція в липні, це зараз буде в нас конференція в жовтні. Тому, крім того, дуже дякую вам, що ви прийняли нас спостерігачем в асоціацію вищих адміністративних судів і державних рад країн Європейського Союзу.
That was were conferences in July and there will be the conference in October. We sincerely grateful to you for our joining to the Association of the High Administrative Courts of European Union in the status of observer.
Це все в системі дає нам можливість в Україні забезпечувати судовий захист прав людини на наш погляд на належному рівні.
In combination, all of this gives us the possibility to ensure the protection of the judicial protection of human rights in the appropriate level.
Незважаючи на рашистську навалу, на ті тривоги, на ті обстріли і так далі, які є в Україні, і вони є у всіх наших регіонах України.
Despite the Russian invasion and air alarms, shellings and other horrible things of war in all our Ukrainian regions.
Тому, користуючись нагодою, дуже вам всім дякую за ту допомогу, яку ви надаєте нам у цій боротьбі з несправедливою війною.
And taking this opportunity, I would like to express my appreciation for your assistance, for your help in our fight against unjustified war against us.
Ми все робимо для того, щоб бути разом з вами у європейській сім'ї, щоб кожен громадянин України мав право на верховенство права, щоб наша Україна розвивалася як демократична держава і щоб основні цінності, права людини були на першому місці у нашій країні, як і у ваших країнах. Дуже вам дякую.
And together we make our best to join the European family, to ensure the human rights and the rule of law, and to make our citizens live in safe, democratic state. Thank you very much.
І ми обов'язково переможемо рашистів.
And we certainly will have victory over racists.
Дякую.
Thank you very much.
Thank you. Thank you very much, Honourable Justice Michail, President, Supreme Cassation Court, Ukraine Supreme Court, for your response.